You're recording.
Hello, thank you for joining us today for our LGBTQ Do-It-Yourself Estate Tips webinar, particularly about how to deal with these kind of issues during the COVID-19 outbreak. This presentation is titled Preparing for Your Future Needs and Honoring Your Present Self, and it is part one of a two-part series that will be followed up on Wednesday, April 8th with a live Q&A about this material with the three presenters from 3 to 4 p.m. It will also be a Zoom webinar that we'll be sharing through a link. So thanks for joining us today. We expect this material to last about an hour and 15 minutes to an hour and a half. We're gonna spend a little bit of time going over some really important information relative to some key documents that you'll need during this crisis time that can be really helpful, and the LGBTQ specific intersections for those documents. And then we're gonna spend a really good chunk of time at the end actually looking through each of the documents. So a little bit about who we are. This is a presentation, a collaborative effort of the QLaw Foundation of Washington, Lavender Rights Project, and the Smol Law Project. And so you can check out this slide that you can see on your screen right now to get more information about us. And one of the last slides at the end of the PowerPoint as well has all of our contact info. We're gonna all be on the call next Wednesday, and we'll be able to tell you more about ourselves and our businesses, and I'm gonna hold that time for then. But I encourage you all to connect with all of our different social media to learn about us and the different services that we can provide and the ways that we can help you out. Also, just a side note, all of the documents we're going to cover today, as well as some extra sort of helpful supplemental documents and a PDF version of this PowerPoint, are going to be available on the website connected to this event for you to be able to download, to fill in and change as you like, either on a Word or a Google Docs type program, or even for the more lo-fi folks out there, the way that these estate documents are made, you're able to just print them and fill them out by hand as long as you're doing it, in blue or black ink, so that you don't have to even be very tech savvy to navigate and use these documents. All right. So what we're going to do today, I already covered this a minute ago, but we're going to talk about issues for about 10 minutes. Then we're going to dive into the actual kind of details of the documents that we're going to be addressing. Estate planning, particularly when we talk about a complete package for an individual, it really covers a lot of areas of life and quite a lot of different documents. And I'm going to briefly mention some of the ones related to what we would call death-related processes or funerals and wills and that kind of stuff. But most of today, and the documents we're focusing on for today's workshop and for the Q&A to follow today's workshop, are healthcare directives, powers of attorney, and sort of special issues related to those things around the current COVID-19 outbreak. And some particular considerations that LGBTQ plus community needs to be considering during this time related to our identities. I think one thing that is really important to say that I didn't mention in the presenters part that we'll all talk more about next week is that this is a by and for community event. So we are all LGBTQ practitioners in the legal field, out serving LGBTQ legal community, and all of this is drawn from our personal and professional experiences, and we're very happy to be able to share this info with you today. So a lot of the examples I'm going to give are drawn from my life as a queer person and as a trans person, as well as from my professional experiences as a legal professional supporting these kind of issues for many years. So we're going to dive into those issues, and then we're going to go over the forms, hopefully for just about 30 minutes, but it's quite a lot of forms and info, so it might go a little bit longer. And then I'll be peppering little reminders to everybody throughout the presentation to tune in for that 1 hour Q&A, April 8th at noon, or I'm sorry, from 3 to 4. We changed that time, so I actually just caught a correction on that slide. It's mentioned a few times. So a reminder to everybody, it's going to be April 8th from 3 to 4 on the Zoom webinar. All right. I always like to open these workshops with a little bit of humor because what else are we doing today other than talking about the materials and the documents? We're starting important conversations about really hard to talk about topics. Folks are often loath to do their estate documents because of, as we all can understand, the challenging values and personal decisions and kind of processes that go into these documents. So I always like to start with a little bit of joke and a little comic to get everybody kind of in a good mood to talk about these hard things. And for LGBTQ folks, one of the things I always like to say is that, you know, we fight very hard for our rights and our protections in our life, and we should just as much try to protect ourselves and our families and our relationships and our identities through these kind of special legal documents. So you can see a little joke here on the screen. It's a comic where a person and their dog are in bed, and the person has just executed an advanced healthcare directive and says, you know, here's the first draft of an advanced healthcare directive that I wrote for you. It says, kill me if I have a headache, kill me if I'm itchy, kill me if I complain too much. And then the dog says, there you go, you're complaining too much. So the person says, I might have some edits, right? So it's pretty funny and lighthearted, but it also brings up a really good point. And one of the things we're going to talk about a lot today is that you really need to craft your documents to be specific to your circumstances, your situation, your values, your life preferences, and your medical health and identity needs. And then there are some things that are going to be really universal. We're going to be talking about some pretty specific COVID-19 edits, things that even as a legal practitioner who's been making these documents for many years and has specialty training around these issues, I had never considered some of these issues before. And I had to craft special language for our documents related to some of these COVID-19 things that come up. So we're going to have some special edits that we're going to talk about, and I will try to bring as much good humor and lightheartedness to this conversation as we can, and I encourage all of you to do the same when we come together in our live talk next Wednesday from 3 to 4 on April 8th. Okie doke. So, sorry about that. So a quick intro. LGBTQ do-it-yourself estate planning. I always like to say that every person, no matter your age or income, should at least have the following documents. And for folks out there who aren't lawyers or who might not have executed these documents, this can seem intimidating, right? You have a list of 5 or 6 things in front of you, many forms you may have never seen before or never finished on your own in different ways before. But these can actually be pretty simple forms, and most of them, including wills, can be fill in the blank in our state, where you can handwrite in a pre-made form as long as it's otherwise executed in valid and proper ways. And there's a lot of reasons why, no matter your age or income, you should have a complete package. And so what a complete set of estate documents looks like in the most basic sense would be a basic will with funeral instructions, which I will mention briefly right now, essentially to say that there are death-related documents and life-related documents in the zone of estate planning. And they are kind of 2 very different and distinct conversations. We hope to follow up this webinar in the future with a second round webinar series about funeral and death-related and will-related concerns, specifically considering LGBTQ needs around the COVID-19 crisis that we're all living in right now. But today we're mostly going to focus on the life documents. So the website will include a copy of some simple wills, funeral instructions, and sort of helpful documents that you can use if you want to go ahead and execute those for yourself. But we do hope to follow it up with an actual webinar to support those materials. So for today, we're going to focus on kind of the rest of this list, which is the life zone, right? So the documents that apply when you're still alive. So funerals and wills, those are the documents that actually only step in, or kind of they only, you know, take power after you have passed, after you have died. So for the life documents, we're looking at things like healthcare directives. You might also know them as living wills or advanced care directives. And they're sort of, especially in our state, in Washington state, their kind of necessary counterpart, which is called the POST form. Your doctor is probably the most likely person to have talked to you about this, and it's called a physician's orders on life-sustaining treatment. Healthcare directives we'll often call HCD, and during this presentation, you'll see often that I call them HCD. We're going to go in depth about all of these life documents, so don't worry about remembering all this. And remember that you can download and save the PDF copy of this so you have the notes in front of you for your permanent keeping. And then finally, we're going to talk about powers of attorney, both for finances and health. These are really important in situations that we're all dealing with right now around folks being able to access each other in hospitals if you are not married partners, if you're non-biological family, if you're chosen family, if you're friends, if you have a poly relationship where you need to have access and visitation outside of a traditional biological or married family unit. So there's a lot of important considerations for powers of attorney issues that come up, and sort of treatment considerations around LGBTQ and COVID-19 needs that we're going to dive into, as well as a brief talk about HIPAA releases kind of in that too. And then one of the things that I always like to tell folks is absolutely critical when we're looking at how to make sure that you have an adequate self-made estate plan is that none of these documents are effective if the folks that need to use them don't know where they are, don't know how to use them, or can't access them even if they know where they are. So a good example is that if you keep your documents in a safe deposit box, oftentimes it can take the documents themselves to get access to the safety deposit box. So I recommend that originals be kept in a very safe place, like a safe or a safe deposit box, things like that, but that workable copies, copies for people to have, particularly of healthcare directives, posts, and powers of attorney and HIPAA releases. Those are documents that copies are effective as the original, and you should have them readily available with instructions. You'll notice in the website materials that they're, particularly in the wills and funerals folder, you'll see some very helpful notification lists, a couple different examples, and they are very long, comprehensive documents that you can just handwrite, fill in, that will notify your caregivers of where the documents are, what is in them, a lot of important information that you need to share, and those kind of things. So again, these are really powerful tools, but if you don't tell folks where the toolbox is, they're not going to be able to help you during these really critical moments of need. And one other last tip that I like to give is that, people don't think about the power of these documents until those crisis moments when you don't have them, and that's when trauma occurs or is exasperated. So what is often already very difficult situations will be made either easier by the presence and easy access of these documents, or can be made harder by the frustrations of trying to find them and find out what folks want. So let's dive on in and start looking at some of the specific risks are for our population, for our community, specifically to these documents when we're talking about healthcare directives and powers of attorney. So for LGBTQI folks, when we're looking at our life care documents, so when we're looking at our healthcare directives, which tell people what kind of medical treatments we do or don't want, and other kind of care and life directives, and we look at our powers of attorney, which are the documents which tell people who gets to make those decisions about what we want and who gets to access our information and our records and accounts and things like that. So as gay, lesbian, bisexual, trans, queer, intersex, gender diverse, non-binary, as we're a very broad community that shares very diverse identities coming from many lives and many backgrounds, but we do have some universal risks. And particularly when it comes to estate planning, they're very similar, no matter whether you're coming from a position of being a queer person, worried about your sexual orientation and your romantic relationships being recognized during this issue, or whether you're a trans person and you're worried about your gender identity being protected and honored during care. So some of the biggest risks, if you haven't completed these documents, or if you haven't completed them effectively or accurately or validly, would be that biological family often can have the first right to decide care if you were incapacitated. So a good example would be, I'm going to use some hard life examples during this presentation. So here's a little trigger warning. We're talking about things that are going to be risks to your health and life today. So I'm going to use some examples that can include some pretty heavy circumstances. So let's say I get in a car accident on the way home tonight from this event, and I go into care. I'm incapacitated in a hospital for a long amount of time, and I'm in a coma. During that time, the person that gets to decide a lot of my care, if I haven't executed a healthcare directive and a power of attorney, would be my biological family, and the nearest one, which would most likely be my mother or my brother, which could or could not be good for me depending on the circumstances. We all know, as LGBTQ people, many of us have relationships with our families that would be challenging if that person or any of our family members were allowed to have care over us. And so for many LGBTQ folks, protecting ourselves from transphobic or homophobic family members is actually a really important and critical part of these documents. So one of the things you can do is exclude anyone in your documents. So you could exclude biological family in general, or you can make a list of folks you want to exclude. It can also include ex-partners and things like that, you know, folks that could be a risk to your safety. You have a right to name who can be the people that can be caring for you and speaking for you. You also have a right to name who you would not want to be able to make decisions about your life, your resources, and your body and care. Some other big risks, and this is a risk for everyone in general, but for LGBTQ folks, as we know, particularly trans bodies, we can face a lot of bias in medical care, particularly in crisis or emergency settings where people are having to decide whether to keep us alive or not. And so people without healthcare directives and POLST particularly could be kept alive or allowed to die against particular wishes of the person if nobody knows what they are. So for a lot of my clients that I have supported, they feel very firmly that their time is their time and they're going to be ready to go. They don't want to be kept alive more than 48 hours. But for other folks, some folks want to be kept alive for personal, physical, spiritual, other value reasons for a very long time, even if it would create a burden to their body or their loved ones. So that's a very important values decision that will be made for you if you do not have these documents properly completed. For trans folks like me, for other gender diverse folks or non-binary folks, you're always going to run a risk of being misnamed and misgendered in care, or having biological family get triggered to have the priority of being able to be your caregivers, at which point they would be in control of who gets to call you what, according to pronouns and genders. And so a good example, my documents are mixed. So I have a birth certificate that still says an old name and an old gender, and most of my IDs now for many years say my current legal name, which you've seen is Dusty, and my ID has said male for many, many years, but my birth certificate still says female. Because of that reason, many times when I go to get medical care, I've never updated my gender marker on my social security record. So I will go get medical care and medical providers will be able to see somewhere in the record that there used to be a female marker. And it has often caused problems for me when I've been able to just advocate for myself and had total capacity. So you can imagine the host of issues that can arise if you don't have capacity and you have not designated these things ahead of time. This is a good point to mention that in all of the document packets on the website, you'll see that there are transgender versions of the documents and the not transgender versions of the documents. So there's a healthcare directive just for trans people like me that I created with some special considerations for us. And there is power of attorney form that's slightly different as well. And so pay attention to filling out the correct ones. But I want to bring it up because for folks who aren't trans, but might want to exclude biological family or exclude abusive partners or things like that, abusive ex-partners, you still might want to take a look at the trans versions of the documents because they have pretty good exclusion statements that you might want to include in yours. The documents are pretty easy to edit as well, so you can chop and paste and cut and combine how you might like. Similar to biological family being triggered for your care, transition-related care could be stopped, and a court can assign someone to decide your care. So beyond transition-related care, any other kind of care where it could be considered a non-medical necessity decision, even if it's important to you, those kind of things could be stopped or changed. And all of those can be directed ahead of time through these documents. One of the most important ones that people don't realize is that a non-married partner will not be able to visit you necessarily, nor will they be able to decide end-of-life care for you or access your accounts or manage your affairs unless that partner is a co-account holder. And so this does not matter if you have been living together 30 years. It doesn't matter if you had a domestic partnership that did not convert to marriage, even though many others did. If you were not married since gay marriage has become legal, you essentially are going to have these documents to be able to access your partner. If you're a poly person, you're in a relationship with more than one person that you would want to be able to access you. Anybody that is the non-married partner would have to have these kind of documents to be able to visit you, to care for you, to help manage your affairs. So particularly for diverse relationship types, these kind of things are quite important. And for folks who are not going to be relying on the traditional biological or married family model, which is many LGBTQ folks, it's quite important that we be able to describe and nominate people who aren't going to be under those normal structures. So for example, we'll use myself in the documents in a little bit, and you'll see that one of the people I often nominate for care or for decisions is my brother, who I am very close with, but who also lives nearby where I live, so would be an easy person practically for those kind of decisions. But I also nominate one of my best friends, right, who I'm not biologically related to, who would otherwise have no rights to me, who would not be a person that would actually be able to get access to me in any of these other circumstances short of having these documents. So again, a quick reminder, like you'll see on the slide, because this comes up so often when I do these kind of workshops, live-in partners and any partner who is not legally married to you will not have rights to your care, to see you, to make decisions for you, or to access your accounts unless you say so at a power of attorney. And that actually also goes for stepchildren unless they've been adopted, poly relations, chosen family. Again, anybody that is essentially not a married, biological, or adopted family member. Exclusions are allowed, so I'll talk about that a lot. So you can exclude the homophobic family members, you can exclude transphobic people, you can exclude ex-spouses. And particularly in the power of attorney documents, you are able to assign guardianship for minor children, for pets, things like that. Vulnerable adults, if you are in this position where you're taking care of a parent, such things. Otherwise, again, think about the kind of chain of responsibility. If I'm responsible for my father, if he's a vulnerable adult and I'm taking care of him, and I'm suddenly incapacitated, who is going to be taking care of him if I'm his guardian? So you should be suggesting guardians for whomever you are responsible for in these documents as well. All right, so that's a pretty good quick crash course and intro. And the one universal thing about all the documents is that most estate documents have very, very stringent and explicit witnessing and what's called execution requirements. And in Washington state, particularly for the ones we're talking about today, the minimum is that yourself and two uninterested witnesses, and I'm going to talk about what that is, must be present at the same time while you sign all these documents. So my practical advice is that you fill in your healthcare directive ahead of time, but you don't fill in the page numbers, you don't fill in the date, and you don't fill in the signing portions until you're actually all sitting together. Because in my experience, often up until the day of signing, things change, a page will be added in, will be taken out, that kind of stuff. So when you're actually all sitting together, the three, at least three of you, and right now under COVID, there's some kind of special issues we'll talk about, but as it stands with Washington law currently, you have to be physically present with each other. And we'll give you some tips about how to deal with that with the 6 feet requirement right now and things like that. But the minimum practice to be valid, otherwise these documents won't be legally valid, is that you must sign it at the same time as your two witnesses sign it, while they witness you having the capacity to make that decision, not being under duress, and all of the typical things that come in a witness statement. I also encourage LGBTQ folks, if you're able to have a notary present. Online notary is available now in Washington state, at least emergency style, through April 26th of this year of 2020, and that could be extended through additional orders if it ends up happening. So there are some ways to get this that need met right now. It is important to know that at least in emergency times right now, notary isn't necessary. It's a best practice that I encourage because it makes your documents as valid and legally sound as possible. And so under normal circumstances, when we're not all in a crisis and we can return to more typical social interactions, I always encourage people, you must have two witnesses that are uninterested, and ideally do it with a notary at the same time as well. The forms included are specific to each document. So you have one for a healthcare directive, and you have a different witness form for your powers of attorney. You can remove the notary statement in your Word document, just take it out if you need to, if you choose not to use a notary. But leave the witness statement that's in there. When you see the documents, it will be quite clear. And then who is a good witness? So again, you're going to have it in the document itself. It will say to you, because your witnesses will have to state this, that they don't have any of these relationships to you. But an uninterested witness is a person that is usually a friend, a neighbor, a coworker, someone who you're familiar with, who knows you, who's going to be able to say, oh yeah, I know Dusty, and Dusty totally had capacity. He seemed very normal today. You know, he was clear what these decisions were. He knew this was his healthcare directive. He knew what he was executing. But those folks should not be so close to your life that they are mentioned in the document in any way. They should not be people that helped you make the document. So for example, your attorneys should not be witnesses if you have an attorney making these things for you. They shouldn't be people that will benefit from the document, right? So your heirs, typically your executors, your agents, the people you're going to appoint, often should not be people who are witnessing these documents. No one that's related to you by marriage, by partnership, by blood or adoption, even people that you're dating or lovers should not be witnesses. So you've got a poly relationship situation and you all want to execute documents together. That's great. You should not be each other's witnesses. You should definitely get third-party witnesses for those documents. And particular to the medical directives, the healthcare directives, you really should make sure, and the powers of attorney, and this is particularly comes up for elders and for folks living in treatment or in healthcare settings, facilities where they might have a pretty limited social life and they don't necessarily have access to a lot of witnesses or potential witnesses. No one who is going to decide about your healthcare or receive payment or benefit of your healthcare can be a witness, right? So we really need to think about people who are really removed from the process, people who are just there with their only role and their only involvement in any of it is basically to be a friend or a witness to you to sign it. At times, at different community agencies, we have partnered up to have community witnessing parties where a group of us worked on these documents together over a few weeks and then did a witness and notarizing party together where volunteers of the agency were able to be witnesses and attest to everybody. So there's some creative ways to get around it if you're a person that's concerned about not having enough people in your life who would be able to be interested witnesses, particularly if they're going to be mentioned in your documents. All right, so now, how do we deal with all that witness stuff during COVID-19? So as I mentioned before, right now, Washington law does currently allow for us to do online notary, at least until April 26th of this month and possibly later if it's extended through this emergency order. So if you're going to have a notary, work with that notary to join you and your witnesses online in some video fashion, similar to probably what we're doing today on this webinar, but it will have to be face-to-face. The notaries will have special requirements they will make you meet, whether it's in person or online, including showing an ID that must match how you're going to be signing and executing the documents. Currently, though, different than notarization, witnessing cannot be done electronically or via video in Washington state. So what this means is that it presents a pretty significant challenge for folks who are wanting to execute these documents during this outbreak, right? Where we're all trying to stay at home, we're all trying to practice social isolation. Many of us are medically necessitated to be on quarantine. So how are we dealing with this during this time? So again, a reminder is that for your healthcare directives, your power of attorneys, your wills, your funeral instructions, they really need to be witnessed by two witnesses present with you at the same time. So some ways to get around this is using people who are already close to you or in your sort of care network, people that have been dropping groceries off on your porch if you are in quarantine, people that have already had some contact with you, your neighbors, folks that you're able to be physically around without increasing your exposure. Or if they're folks that you maybe haven't been around, but want to limit your exposure. For example, I live among many neighbors, but I haven't seen any of them in weeks, right? And so none of us have been physically closer than 6 feet to each other in a long time. My roommate who I live with would probably be a bad witness because she's going to be mentioned in one of the documents. So a good idea could be to go to one of your neighbors, reach out, send them a text, give them a call, holler at them over the fence when you see each other outside and ask if they might want to do this, or, if you've got a faith group or a community group of any kind, same thing, reach out to your social network of folks who would be safe to come in contact with in some way and do the practice of passing forms, but you have to be able to see each other. So you wouldn't be able to pass forms under a door you couldn't see through, that kind of stuff. You could pass forms through a window, you could pass them over a fence, pass them through a house window or a car window. All of the kind of creative ways that people have been navigating, creating barriers while interacting with each other can be applied for witnessing and executing your documents during this time. You could cover them in disinfectant. Everybody can be wearing masks and gloves. The problem is that even if you stay 6 feet apart, you're going to be both touching the same documents immediately and around the same time as each other, right? So again, if you can, wear gloves, use separate pens, right? Don't share pens. All of that kind of practical information around how to navigate these social interactions we're all having to go through right now, but specific to the signing of documents. And I do want to mention almost all your other legal documents right now in Washington State, and there's a caveat that almost, so it is not all, but most court documents you're going to be able to actually DocuSign or electronically sign, and most courts are going to be accepting them right now, but not estate documents. So this is actually the one zone where it's quite important that you sign with your witnesses exactly how the law requires you to do so. Okie doke. So let's dive into the documents now. So we're going to talk about the healthcare directives, powers of attorney, go over the HIPAA releases, which are usually a part of the power of attorney, but because of the crisis right now, we pulled them out to make a separate individual document like you might normally complete at your hospital, just so that people have them for quick and easy use. And then the post form, which we'll go over in depth as well. So the first zone that we're going to talk about is healthcare directives. And healthcare directives are essentially the what do you want done? And then the next zone we're going to talk about is the power of attorney. And power of attorney forms are basically who gets the right to say what's being done when you can't say that for yourself, including for your health or your finances. So for healthcare directives, and as we walk through the forms, I'll be giving examples and we'll be going through what all these things look like on the forms we've included. But here's a quick rundown of what healthcare directives do. They're going to list your desires for resuscitation, under what circumstances you would like your life prolonged and in what ways. They're going to list your preferences for care in general. This is not just limited to end of life decisions, right? So again, as a transgender person, one of my preferences for care that I list is that my transgender care be continued. The trans specific document I've included for your healthcare directive includes some very specific language around preferences for care for trans people that might not be in other traditional healthcare directives, but are going to be very important for us, particularly if we're in care for a long time, which is a big risk right now, right? So a lot of folks who are going to be needing intensive treatment for COVID-19, it's not a quick recovery. And so folks are looking at, oftentimes being hospitalized for quite a long time. It also can determine other preferences of care you might not have realized that we'll dive into, including if you are to die while in care, would you prefer to die at home or at a hospice or at the hospital, that kind of stuff. It lets your medical providers know about your regular medications, treatments, health issues. It assigns organ donation and last rites. People don't often think about that. They think, oh, that's death stuff, so it has to be in my will. But no, it's actually while you're still alive, right? Organ donation is a tricky zone. So your body release and your organ donation is actually the mixed zone that can overlap in both life and death documents, but your last rites are while you're still alive. And you can at least request whether you want them or not, and according to what faith or what faiths you don't want them to have. You can list your primary doctor, you can list the backup doctors, you can list preferences of places for care. One of the things I want to plug right now is that we're including the statutory state form for a mental health care directive. There's also really great resources on End of Life Washington for a dementia specific healthcare directive. So for folks who are living with special issues like dementia or mental health realities, those specialized healthcare directives are quite important to look at and think about if they might be one you want to complete in addition to your regular healthcare directive. So they're supplements. They're not to replace your normal healthcare directive that will help people decide your care during emergencies and critical and long-term conditions, but they will help address things specific to you. So for transgender people, for a lot of LGBTQ people, for a lot of PAWS people, institutionalization for us for mental health issues can have a whole lot of risks that other folks won't be living with. And so, and for folks who are living with depression, we're a lot more likely to have mental health issues. So a lot of us have a history or reality of needing or being forced to be institutionalized at different times. The mental health care directive from our state is incredible. It's very in-depth, and it will allow you to not only list your preferred hospitals to be treated at for mental health issues if you need to be institutionalized for any duration of time, but will also allow you to name and list preferences of care for your mental health treatment, and really goes in depth. It's about 20 pages long. And same thing for dementia. If you're a person or one of your loved ones is living with dementia risks or realities, there's a really, really good dementia healthcare directive. They can list a lot of very specific issues that otherwise will not be dealt with in normal healthcare directives. So I encourage you to seek out those supplement directives that might be helpful for each of your individual personal circumstances. But back to the general directives, they can also consent to things like ventilation, experimental treatment. The one that I crafted for us to use today, we're going to go over. It has all of the regular extension, prolonging, or allowing to end of life kind of treatment decisions, but there is an entire special section just about COVID decisions. The reason that we did this is because a lot of the treatments for COVID-19 right now are not only experimental or non-traditional, but they require longer periods of treatment than normal. So for example, if I were to get in a car accident today, I needed to be on a ventilator after a car accident. Under normal circumstances, I might only want to be on a ventilator for 3 months. But with COVID, it could be very normal and common to be on ventilation for up to 6 months. We don't know how this is going to turn out. And so you might want to have 2 different values going on the same documents based on these treatments specific to issues like COVID. So we'll talk more about that in the documents here in a minute, but that's a first introduction to that sort of consideration you need to be having. I think too, as we start to dive into these more specific issues now, where hopefully your brains are starting to get moving and your hearts are starting to get moving about the sort of hard personal values assessments that go into these things. At the end of the workshop, at the end of the slides, there's a continuing resources slide, and I want to draw your attention to that to look at later, because particularly a few really good resources, End of Life Washington, Northwest Justice Project through Washington Law Help, and Legal Voice, they've all put out a lot of different really helpful do-it-yourself estate planning and healthcare directive materials. And one of the ones that's really helpful that both Legal Voice and End of Life Washington have are values worksheets, where you can kind of go through a sort of values assessment process with yourself about these decisions. About, okay, if I'm in a car accident, I want to be on ventilation for how long? What if my quality of life is this? What if it's COVID? What if it's cancer? And you can kind of start to go through a sort of checklist to figure out from, you know, hot to cold how you feel about all of these different issues. You can also leave that for your caregivers so that they can have that as information while they're making these hard decisions for you. And I encourage you to leave a letter as well, a sort of like, dear family, dear loved ones, you know, here's what my thought process was going into these decisions. So you're going to instruct about treatment that you want or treatment that you wouldn't want with these directives. And in a small way, it'll let you list your values. It's not going to be as in-depth as the values assessment worksheets. Those are not actual legal documents. Those are what I would call supplemental helpful documents. But within the healthcare directive itself, within that legal document, it will let you, to some degree, name and list values. And one of the really important things that comes up around COVID stuff right now is that the healthcare directives and the power of attorneys both can address visitation, and they can address exclusions for visitation, right? So if you, you know, have a person that you would not want to be able to access you, you are able to mention that. But one of the really important COVID issues that I'm going to mention a few times is that right now, as you've probably heard, folks can't visit COVID patients. So, and this includes even caregivers sometimes. So you, if you are in inpatient treatment for COVID-19 or COVID-19 related conditions, you are going to be isolated extremely, and you're not going to be able, even folks that you have said can legally visit you and that normally would have those rights are going to be restricted pretty significantly. So everybody, you know, just one of the sort of emotional preparation things that everybody needs to do as you work on this stuff is realize that, you know, your normal visitation rights, you're going to enumerate and you're going to describe considering most normal circumstances, all of which are hard and challenging, right? It's like, who's going to be able to visit you after car accidents? Who's going to be able to visit you during cancer treatment? Who's going to be able to visit you if you're inpatient somewhere? But then again, you need to think about, and what about during COVID? What about right now, right? And so your visitation things, you know, you're going to be saying who you want it to be, but of all of the things that you are directing around COVID specific stuff, the one thing that I need to, you know, make really clear is that immediately it's already very obvious across the country that visitation rights are basically out the window. And we can all understand why. So some really specific trans and gender related stuff that I just want to bring up before we kind of move forward. So you can choose to list all your names or not. A lot of folks who aren't trans have had name changes, so this applies to anybody that's had a name change. But for most trans folks, most of us go through a name change at some point in life, and it always comes up whether or not to list all of your names on documents, or whether to be, you know, be quote unquote stealth and to not list old names on your estate documents. And these aren't like job applications. It's not like a, you know, have you had a previous name, and you can get in trouble if you say that, you know, you haven't and you have. This is really personal, so it's up to you. I have had trans clients who want all their names there just to be thorough so that nobody, you know, can challenge it. And then I've had other trans clients that want it to be as stealth as possible. So that's a values decision that you get to make about how you want to be as a gender diverse person on your paperwork. You can absolutely list trans related personal values, like how you want to be dressed, right? So I'm a trans body person living with a very mixed trans body. And if I went into care while I was incapacitated, there could be some pretty significant risks of how I would be dressed or cared for or housed if it is gender segregated. And if I, you know, suddenly woke up in a hospital that had very gender segregated dress and clothing and was dressed in all pink or all women's hospital gowns and things like that, I would definitely have some problems, right? So you want to make sure that you list and describe how you want your care or your presentation of life to be continued. You can request specific trans related care to be continued, like hormones. And the statement that's in there is a pretty good one. So it basically says that, you know, you want your trans related care to be continued as it was, and based on your values expressed at the time it was when you became incapacitated. So we're going to follow up with this, particularly through my program with a trans specific webinar series, where I'm going to go really in depth on all this stuff for trans folks. But a very good example is that many of us will have different relationships to hormones at different times in our life. And so a person might have been on hormones at one time and not at another. And instead of just relying on your caregivers or the medical establishment to just make decisions for your care, it allows you to say to them, hey, look at the last kind of care I was having and base my continued care during incapacitation on that. You can name a preferred provider. For most of us, it's going to be the person that's our trans safe provider. Good example, I have a big medical institution that I use for my insurance, and then I have a personal doctor that I've been with for years who's my trans care provider and who is not part of that insurance network, and she will always be my go-to first doctor on all my listed documents. You can list values of care like being named and gendered appropriately in staff and in records, but I want to give the caveat that medical records are heavily controlled by legal name issues. So you can, it might be a lot of AKAs and stuff like that unless you've actually had a legal name change. And you can exclude and nominate people for visitation. And one really quick death-related thing that I think is important for trans people, and that I've never been asked about by anybody except trans people, because we all worry about it, is that you can pre-authorize, at least in Washington State, and all of this, I think a good little legal side note we should make is that all of this is specific to Washington State and Washington State law, is that you can pre-authorize your death certificate information here. So one of the documents does include that, where you're able to list ahead of time, this is the gender that is to be on my death certificate, this is the name, this is who I'm to be released to, this is the information that's to be released. And for the most part, that can be controlled ahead of time by you, with some caveats depending on your nature of death, with the coroners involved and stuff like that. Okay, so everybody take a deep breath right now. Thanks for sticking with us so far. It's a ton of info. This is a literal crash course, rapid response type material. So normally the healthcare directives and power of attorney workshops are two separate ones. The trans workshop is its own. We've never dealt with COVID issues before, so this is a whole lot at once, coming to you from a lot of different directions. So pat yourself on the back, take a deep breath. You're listening to this on your own time, so you can pause and take breaks anytime you need. But I always just like to build a little bit in to remind everybody that when we're talking about these heavy kind of issues, do a little bit of self-care. We're all pretty tapped out emotionally currently, and these documents can be particularly emotionally stressful for people to finish, even when it's not a crisis like this. But remember, this is an act of self-care itself too, right? When you do these documents, when you execute them properly, when you let folks know ahead of time what you want and who you want to be caring for you, it's an act of love that you're doing not only for yourself, but for your loved ones. Because if you've ever survived situations where you needed these documents or you needed this information and you didn't have it, it's incredibly traumatic. And it will leave you wishing that you had them. So this is an act of care. It's an act of care for yourself and for anybody that's going to be caring for you during these circumstances. All right. So what is the POST compared to the healthcare directive? Most folks, unfortunately, that I've worked with haven't heard of this unless you've needed it because you already are a person who is likely to be dealing with emergency care or has long-term medical issues. Or if you've had surgeries, a lot of times they'll make you complete one prior to a surgery. So it's oftentimes in other states, it might be called like a resuscitation order or orders on resuscitation, but it's more broad than that, particularly in our state. And so it is POST, P-O-L-S-T, is the fancy acronym for physician's orders on life-sustaining treatment. And it is a green two-sided form. This is the one that you can't change anything on. It is statutory, it's mandatory that it stays how it is. And it gives very basic instructions. So what I have been told by medical professionals is that even more so than a healthcare directive, this is the form that's going to be used in emergency decisions, right? So once you're out of critical ICU type moments and care decisions, and you're just, intubated in the hospital, or you're in a stable coma in the hospital, then everybody has time to look at your 6-page medical directive, go through everything and figure out the priorities and plan for your care. When you are in a crisis moment, when medical professionals in an ambulance or in a hospital are deciding, what is this person living with? What are their desires for resuscitation? What are their desires for being kept alive? What are their other medical issues? Medical professionals have told me this is the form that doctors and medical providers look to. And it's because it's a doctor's order. So different than any other form we've talked about today, this form does not need to be witnessed. All that it needs is for you to sign it and date it, but your doctor must also sign and date it, or a doctor that cares for you, because it is a doctor's order, which is why medical providers will listen to it first and foremost. So I often tell folks, if you're in a crisis, if you have limited capacity, if you can only do one form, do a POST, right? If you can't get a healthcare directive done, if you can't do a power of attorney, if you can do nothing else, get the POST done. It's the bare minimum. And it's the one that you really should keep with you the most. It should be in your backpack, in your wallet, if you can have room to fold it up and put it in there. It should definitely be with any of the hospitals or healthcare providers who care for you regularly. If you go into surgery, you should be giving them a whole copy of your entire estate package, but especially the POST. But remember, it's not effective unless your doctor signs it. And it really is encouraged that it's on bright green paper, like bright green front and back paper. So if you're a part of a medical care network of any kind, most of them will have copies they will share with you. We're also going to share the online PDF copy for you to print and fill out yourself. And we're going to go over how to fill it out here in just a moment. But why, as I mentioned a moment ago, the reason it's critical to have both, you need to have both a healthcare directive and a POST, is that the POST doesn't cover everything. It is really meant only for literal emergency moment decisions, like those life or death, 10-minute, 20-minute type window decisions. And a healthcare directive is meant for more thorough and longer type, information access. So ideally, you need to have both. The POST is going to tell people what to do to save your life and to honor your life-saving choices. You know, and the healthcare directive is really about future planning, general care, and values, right? So standard emergency medical protocols are that they've got to follow the doctor's orders first, and they're going to follow the post first. So what's really important as well with all these documents, aside from witnessing and everything going into it, is that you've got to revoke them appropriately as well. And revoke just means cancel, right? So it's a fancy lawyery way of saying that it's not effective anymore. So there's a lot of ways under Washington law that healthcare directives can be revoked. You can tear it up, deface it, obliterate it, burn it, or otherwise destroy it. You can have somebody do that for you if you were physically unable to, as long as it's at your direction. You can write a revocation of it, and that's particularly important. Sometimes different medical places will require that, particularly if you live in care in a facility. A lot of times they'll require a revocation if you change it. And if you have any kind of change, particularly, that would be considered critical. A verbal revocation is okay as long as it's to your doctor, right? So ideally, if you're making big changes to these, you need to be doing it in writing, destroying the written document. It needs to be the original that you destroy, not a copy. And you need to ideally be creating a new one, would be the reason that you'd be getting rid of this. And most properly executed healthcare directives should in themselves, when you write a new one, revoke or cancel any ones that you have made before that. So the ones that we included did that. So if if you have outside documents that you're using, we can't confirm that they would have that statement in there, but at least for our in-house copy that we're sharing with you all, it includes a statement that says any previous healthcare directives have been revoked. Okie doke. So we're coming to the end of the healthcare directive stuff, and now we're going to focus really on current issues with healthcare directives. What are we all considering right now as professional estate planners around COVID-19, and what are we all considering as just people surviving this right now, right? So I know that everybody has been hearing stuff about ventilation constantly. Literally on the drive over tonight to do this recording, there was a whole 20-minute, talk on the radio about ventilation-specific issues related to COVID, and that the mortality rate of folks who go under ventilation on COVID is pretty low right now. I mean, pretty high. The survival rate is pretty low. So ventilation type considerations are going to be really big in COVID-related healthcare directives. And the one that we made has a specific statement about that we'll talk about. Typical statements will say respiration only, but I included ventilation now to be really, really clear. Life-prolonging treatments or hospitalization may take much longer than normal. It might, you need to be thinking about, like I said before, what would you want for your life-prolonging treatment under normal circumstances, which are still going to be challenging and hard and traumatic, and what do you want under COVID-19 related circumstances? Are they the same? Are they going to be different? Another really critical issue that comes up is the ability to consent to experimental treatments, right? So I don't know how much folks have gotten information about this, but quite a lot of the treatments that are going to be starting to be used for COVID-19 or already are being used, and this isn't even just for the vaccines, but just for the treatment, are considered to be quite experimental, particularly blood transfusions. The history of using blood transfusions for SARS and Ebola is one of the biggest learning points for how we're going to combat this virus. And blood transfusions are very complicated issues for people, right? It touches on a ton of personal, medical, scientific, and spiritual values, right? Your blood is a very rich and complicated part of our being. So, and that's just one of the kinds of experimental treatments that could be used. So the statement that we included has some very broad consents there about experimental treatments. And I do want to clarify that you'll see as we go through the forms in just a moment, that these documents are not made to give consent to these treatments. It's made so that you get to decide whether you give consent or not. So you'll see when we get to it that there's a statement where you get to say whether you would consent to those kind of experimental treatments around COVID-19 kind of decisions. And then the visitation issue, again, I'm going to bring in this up a lot, right? Even by caregivers or those named in your healthcare directive or power of attorney, they're still going to be really restricted currently under the COVID-19 just reality we're all living in. And then finally, consent to electronic video, phone, and remote treatment, which is pretty practical, and we can all understand why that would be helpful right now. A lot of these things could be givens, but it's important to explicitly say that, particularly around HIPAA, to be able to say, my patient, or no, I have, my person I'm caring for has consented to be treated electronically, remotely, through video, and so forth. All right, just doing a quick time check, and then we're going to move on to the powers of attorney. So also, one moment, get back over. Oops, sorry about that. Having a slide issue, there we go. So going back really quick, before we start powers of attorney, one of the things that I do want to mention as we're moving into powers of attorney, it's a little bit of a good transitional point, is that last point that I mentioned about consenting to electronic or digital type treatment, there is a special other kind of power that comes up around digital powers in powers of attorney. And that is the power to access all of our digital lives, right? So if you think about it, every one of your accounts, every one of your social media accounts, every one of your email accounts, all of these different things, all your computers, all your devices, they technically all require different permissions and access and different consents for anybody other than you to be able to access them. So, in your healthcare directives, you're going to be consenting to being treated digitally. And then as we move into the powers of attorney that we're going to talk about now, they include consents for a person to access all of your digital reality and all of your digital stuff. So that's a good transition point to be thinking about, what we were just talking about was all of your personal decisions that you're going to be expressing on paper to everybody, to your doctors and your caregivers, about what you want. And now we're going to be looking at who on paper is going to get power to enact those decisions for you when you're unable to do it for yourself. So what a power of attorney does, and this is, similar to a healthcare directive, there are many types of powers of attorney. We're going to talk about the two most basic, the powers of attorney for finances and health, all in one form. They often can be separate forms. Ours is going to be a combined form. The powers of attorney can be executed for any number of legal situations and often are executed and crafted specifically for individual, different types of legal relationships. So the ones we're talking about today are really personal. It's going to be, who I, Dusty, would give the power to make healthcare decisions for me or make financial decisions for me, right? Be able to access my accounts if I was in a position where I couldn't do it because of incapacitation, which typically is interpreted to mean I'm in a coma, I'm in, I'm somehow unable, have somehow in a condition where I'm unable to make those decisions for myself. But it can also include things like being in jail or otherwise, being unavailable, depending on how the form itself is written. So under Washington state law, you can assign multiple agents, you can assign co-agents, you can assign one person for finance and one person for health. My example that we'll go through will be a really good one to kind of help run you through this. But no matter what, you should always assign backup agents just in case one person is unavailable to act, if you can. And again, I really want to pay a little bit of attention to folks who don't have a big social or familial network, particularly a lot of LGBTQ people in general, and particularly a lot of LGBTQ elders might have quite small social lives and have often told me in these workshop settings that they would struggle to not only have enough people to complete these documents, but to also witness them and have backup agents or backup people that they could appoint. So there are just some limitations that people are going to be dealing with depending on your personal circumstance. But if you're able to, try to assign, this would be my top pick and this would be my second pick. One of the very specific requirements under Washington state law, however, is that if you assign two people, one for finances and one for health, which would be called co-agents, not just a backup. So I would be assigning a backup situation. And again, when we go into the forms, this will be pretty clear, would say something like, I, Dusty, give power of attorney to my brother. And if my brother cannot serve, I give it to my friend, Mary. And that would be just a whole power of attorney for finances and health. That's a backup agent type situation. But co-agents is this, and Washington law is specific about this. Co-agent means I, Dusty, give my brother Dan power of attorney for my finances, and I give my friend Mary power of attorney for my health. Now, that means that they are both equally empowered to act, and under Washington law, it requires that your document also says that they can act separately, or they can be required to always have to come to total absolute consensus about decisions, which, as anyone that has dealt with making these decisions as a family unit or in a group of people, can be quite challenging. So this is a sort of, very small legal detail, but is quite important. And the forms that we made include an assignment that says that your co-agents can act separately of each other. And that means my brother Dan doesn't have to get Mary's permission to go and access my accounts like I said he could. And Mary doesn't have to go and get Dan's permission to make my medical decisions like I said she could. Otherwise, if you don't say that, technically the law requires that they have to agree together to act together. And certain medical or financial providers will require repeat documents showing that each decision was made together in concert. So I do encourage you to have backup agents and co-agents, but to make sure that if you if you want it to be effective and practical, you're heavily encouraged to empower them to act separately of each other, unless for the protection of your person, identity, estate, etc., it is important for you to have consensus, right? So if you're worried about people not listening to your values or manipulation, or if you're just worried about any kind of risk where you would want the value of a second party, then you would want to make sure that it does require them to act together. So there's two different types of powers of attorney broadly. There's the ones that start right now, right away. As soon as you sign it, it's ready to go. Or there's ones that are called springing, or it means that they kind of like jump into reality or into being. They become effective once a certain thing happens. So particularly related to COVID, one of the special issues we'll talk about is that you really need to have immediate powers of attorney, right? So you need to be able to just let people have this power right away, so that if tomorrow I wake up so ill that I have to be intubated the next day, that there's no other form that needs to be done. There's no proof of my incapacitation that needs to be provided to trigger this power. Some typical circumstantial types of powers of attorney would be like, I help raise my godson with his parents, and when he comes and stays with me long term, part of every year, when he was younger, he's 18 now, but when he was younger, me and his mom would often have temporary powers of attorney for me to have power of attorney over him, and it wouldn't be effective until the date he was scheduled to be with me, right? So even though she would sign it a month before I would see him, I didn't have any rights to make decisions for him until he was with me, according to the document. So that's an example of when and why you might want a power of attorney that doesn't start immediately. But for these circumstances, for what we're encouraging people to do today strategically, one of the big issues that we wanted to do is to tell folks, if you can and you feel comfortable with it, we are giving practical advice to execute immediately and to have them be effective immediately. And that's what our standard forms include. So you will need to change that if that's not something that you want on your personal forms. Again, they must be witnessed, and they must be witnessed by two uninterested witnesses who are physically present with you at the same time as you signing the document. But I know a lot of us aren't traveling to other states right now. However, if any of us are traveling amongst other states, for anybody that might be watching this that lives close to the Oregon border, right? Folks, down in Vancouver or in Skamania County or over on the coast, anybody that is risking at any time, even just being in a neighboring state, not even other states far away, and an accident happens and you have to be hospitalized in that state, powers of attorney often in other states might not be effective if they are not notarized. So in Washington state, we do not have to have our powers of attorney notarized. But if you're a person where you're like, oh yeah, I drive into Oregon for work every day to drive into Portland, I would heavily encourage you to consider figuring out how to do an online notary while you witness your documents for the time being, because if there's a risk of you somehow becoming incapacitated while in another state, it might be important that your powers of attorney be as valid as possible in that state, which would need to be notarized. And some kind of quick little side notes. So for powers of attorney for finances, there's a kind of side way to get around it, particularly if it is a partnership, if it's people who are going to be sharing finances or accounts anyhow, is to just be a co-account holder, right? So if you're a joint account holder, you don't have to have a power of attorney to access an account. And that can be any variety of an account, right? It can be an investment account. It can be a shared checking account. It can be a kind of beneficiary account, right? So any of our insurance or 401k accounts, they should all have what's called a transfer on death beneficiary, right? So you can assign different accounts to either be transferred in the matter of your death, or as we're talking about right now with powers of attorney, to a person without having to have the power of attorney form by making them a co-account holder or the account transfer beneficiary. And each institution that you're a part of will have those forms. So you go to your bank, you ask either to have a transfer beneficiary form for your checking account or to put a joint person on there. Again, you should consider all the risks of any joint account holder, right? So you need to financially trust this person to not only possibly mingle your funds, but in the least to manage your funds or access to them and not put you at any financial risk or put you at risk for abuse. And you can give an agent in these forms the power to control visitors, but remember right now, even if your form says, if my form says my brother Dan has the right to visit me and to allow anybody to visit or not visit me according to his discretion, the hospital still trumps that right now, right? And they're not going to trump it because of any unnecessary reasons, but because of the COVID risk. And again, you can be assigning the guardianship of your dependents, pets, and vulnerable adults here through your power of attorney forms. So some COVID specific issues that I want to bring up that we might not have talked about yet, and some just to remind you, is that you really should make your powers of attorney effective upon signing them, right? So you'll have the statement in there that your agent has the authority to act on your behalf immediately upon the execution of this document. The ones we made for you have that. You don't have to worry about that. And then there's this whole thing called durability, right? Make them durable. And this doesn't mean that your power of attorney is on leather or is on wood or on a thing that's going to last forever. It doesn't mean you need to etch it into metal or tattoo it on something. But it just means that it is written in a way that says that the person still has power, even if you, the main person that's making it the principal, becomes incapacitated, right? So a good example would be that power of attorney I described for my godson. We did not make that one durable because if I was incapacitated, we wanted decision-making to go back to my godson's parents, right? Even though they were out of town. So if I suddenly was in a car accident, my godson was fine, but he was with me, but I wasn't able to make decisions for him. We did not want that document to have power anymore. We wanted immediately for his parents to be able to step back in and be the ones in charge. So there's a lot of times when you don't want a power of attorney to be durable, but it's very encouraged under Washington law that your general power of attorney for your finances and health be durable. It's also encouraged under the current COVID-19 circumstances that your power of attorney be durable. And what this means is that even if you become incapacitated, if you are in a coma, if you are not able to effectuate and communicate your needs, decisions, your accounts, manage your life, that the person that you assign power to still gets to do that. They don't lose power just because you are incapacitated. So the simple way to make a power of attorney durable is to have a statement in fancy lawyery words like this that says, this durable power of attorney shall not be affected by the disability or incapacity of the principal. Principal means you, the person finishing the form. The ones we made for you include this. So you're set up with these forms to be ready for the general practice under Washington law, as well as the kind of COVID specific issues. Make sure your power of attorneys have a HIPAA release section or form. We have it in the power of attorney itself, as well as pulled out as a separate standalone document to be signed without witnesses that has a little bit of extra information for easier use when you're in a hospital setting. So that's a extra kind of COVID-19 thing that would be helpful. And you have often completed these when you've been in care, even if it's been for something like an outpatient surgery and stuff like that. You will have completed institution-specific HIPAA release at the place you're having surgery and things like that. So we made one for you all that your agents can just give to wherever you end up in care for. And finally, point 4 is that, again, your assigned agents and caregivers may not be able to visit during quarantine. So try to give thorough upfront instructions to your agent. Think about, this is why under normal circumstances, it's important to write a sort of dear family, dear friend, dear caregiver letter to explain your decisions and values. Because everyone has highly specific personal decisions and values around these issues, and none of them are wrong. No matter how different they might be from one person to the next, they are all important and they're all singular. So try to explain it as much as you can ahead of time through some format to your agents, because again, as you have seen all over the news and all around us, people get sick very quickly. And with this disease, particularly with this virus, the ability to communicate oftentimes gets interrupted very quickly. It ravages lungs quite quickly, and oftentimes people have to be intubated much faster than traditional pneumonias or other influenza type viruses. So you might lose your ability to communicate rapidly, and it might be interrupted for weeks or months. And it could be very difficult for you to express not just your desires around healthcare desires, but your power of attorney issues like, where is your account? What are your account numbers? What institutions do you have accounts at? What are your bills? What bills need to be paid? Who do you pay them to? If you imagine someone having to step in to manage communicating with your healthcare providers and manage communicating on behalf of your financial life, that is what your power of attorney agents will do. So try to get them set up for that as much as you can ahead of time, so that when they have to do it, they've got all the information that they need. And again, these documents have a special process for being revoked, just like healthcare directives. When you die, it's revoked. If you're going through a dissolution with your partner, when you file the dissolution, it revokes any powers of attorney that you had with the partner who you were married to. Dissolution is the fancy word for divorce. So if you haven't gone through a divorce, you might not know that, but in Washington State, they're called dissolutions. Formally revoking, which is similar to the healthcare directive revocations or cancelings, where you tear it up, burn it, rip it up, and it has to be the original though, where you do a formal writing. The deed is accomplished if it's a deed specific, and what I mean by that is, I was caring for my godson, I had the power of attorney to care for him. When he went home, the power of attorney wasn't effective anymore because he wasn't with me anymore. If you made one that is not durable and you are incapacitated, then your power of attorney will no longer be effective once you are incapacitated. That's why it's so important to have that statement that says this power of attorney is effective even if I'm incapacitated. Executing a new power of attorney will revoke old ones as long as the new power of attorney says that. So not every power of attorney has the revocation statement in it. Most standard and statutory forms will, and the one that we made for you does include that. And it's best practice to notify your agents that you have taken away their powers if they knew they had them. So many times you will create and execute and destroy estate plans without anybody knowing as you go through updating this stuff. I know, I had surgery in June to remove a gallbladder, and the estate plan that I executed in June, not even a year ago, I would already change over half of at this point, just because of some life changes that have happened. And so everybody that is in that estate plan might not necessarily have the powers now according to my new one. So it's important that if people knew that, if I had told Dan, my brother, hey Dan, you're my financial power of attorney, just a heads up if anything happens, but then I changed that, I might want to let him know he's off the hook. Otherwise, he could try to act on that power of attorney, not realizing if something did happen that you had actually revoked it. Okay, special kind of release that's included in the power of attorney that's very critical right now and that we have pulled out as a separate document is the HIPAA release, right? Health information, portability, I forget the last day, I believe it's Access Act. So this is really about the fancy way of how do we share medical records and information while honoring the confidentiality of patient privilege. As we all know, hospitals and medical providers are fierce about their enforcement of this. They should be and need to be. So most commonly, it's going to be in your power of attorney form. It can also be a standalone form. It's often practical to have it that way. If you want anyone to know what's going on with you medically while you're incapacitated in treatment, including if you're moved to locations during quarantine and those kind of things under COVID-19, you really need to sign a HIPAA release. Otherwise, it's likely that only biological family or married partners will receive medical updates about you, if even then. Currently, with the overwhelmed state of most medical spaces, I think that even the typical folks that would be receiving updates are struggling to get them. And oftentimes medical providers still want HIPAA releases for those folks as well. So we have a very federal law specific HIPAA release that we've included that we'll go over here in just a moment. And one quick note that I always like to remind folks of that's come up a ton during these kind of do-it-yourself estate practice seminars I've done is that many medical providers or folks in the medical industry have told me you often can't pay medical bills on behalf of someone unless you also have a HIPAA release. So it's not even just the medical communication around treatment and around, hey, is Dusty out of surgery yet? Or hey, you know, what was the results of, you know, Dusty's MRI and stuff like that. But it could be something as simple as, hey, how do I pay Dusty's deductible bill here at the hospital for his surgery? You might not be able to do that, even if you are a financial power of attorney, if you don't have the HIPAA release. Okie doke. So this would be a good time if you're listening to this on your own and you want to take a break. Just take a break and kind of stretch your neck for a minute, shake your hair out, you know, just sort of roll around a little bit wherever you are and take a deep breath. We're going to go through a real quick crash course now in the forms. If you are able to, it could be really helpful for you to either have a printed version of the forms in front of you or to have them pulled up in the editable version that you might be using in whatever digital way that you're looking at them, either online or as a PDF in Google Docs or in a Word doc or HandCom editor, any of the different editors you might be using on your phone and whatever Apple editors you might have. So get the documents together, get them ready, put this on pause for a second. The first ones we're going to look at are the healthcare directive and POLST, and then we're going to look at the powers of attorney forms and the HIPAA release. And the forms are made to be filled in, so you'll be able to tell on the screen, ideally, the things that I wrote in as the examples, but I do think if you can have the blank, not filled in forms in front of you, it will be the most helpful for being able to figure out what I'm talking about. All right, so we're going to start with the healthcare directive. I know, and I apologize that it's a little bit smaller than I normally would like as far as screen visibility, but hopefully if you notice when you get into the drive, I have shared the PowerPoint as a PDF. And if you open it as a PDF, once these fillable slides here for the end half of the presentation are lined up in the PDF, they flow together and you can see them read as one long document. So it's a little bit easier to understand. So one thing I said at the very beginning, I'm going to remind folks of right now, is that you should not sign, fill in the dates or the page numbers of your documents until the day you actually are signing them with your witnesses. Everything else, though, you should not only fill in ahead of time, but you should fill in ahead of time and then think about and sleep on and then fill in ahead of time again and really just make sure you're not deciding any of this stuff last minute on the day that you're going to witness and sign it. So on page 1 of our healthcare directives, you're just going to see that you need to add in your name at the top where it will say healthcare directive 4. I put in Dusty Weber, using myself as the example here. And then you notice under that it says, this healthcare directive is made on this day of blank month of blank year in blank Washington. So this is a very traditional opening statement where you're going to write in the day, month, year, and place of when you actually sign it, not when you're filling it out. So if I'm starting to fill it out today on April 1st, but I don't actually get it signed until April 15th, I'm going to wait and fill in that part for the 15th day of April, or on the 4th month of the year 2020 in wherever the city is that you live in or the town that you are signing it in. So in Seattle, Washington, if I'm doing it here. So that is one part that I left blank on purpose to remind you that you should not be filling that in ahead of time. You should be filling those in on the day that you actually sign it. So then at the beginning of the healthcare directive, under point A1, you're just going to put in your name. And for these kind of documents in Washington state, you can either type them on a typewriter, you can do them on a word processor, like I've shown on the screen here where it looks typed in, or you can handwrite it in. It is totally appropriate to fill it in, just literally fill in the blank on the form, but you need to use blue or black ink and be as legible as possible. So on the forms, it's essentially, I'm going to give a little bit of rundown on what the forms include, but mostly we're going to be focusing on the fill in the blank spots. So here on this first page, it's basically saying that you are a person that has capacity to make these decisions, that it's voluntary, it's willful, and that you know that what this directive is saying is that it's talking about how to either prolong your life or allow your life to end. It also says that, if you've appointed a durable power of attorney, that you ask that that person be guided by this form. And it helps to kind of start directing that you want treatment not only to be withheld, but also to be provided as you have been directed. So a lot of times people think about end-of-life treatment as just do not resuscitate orders, but it's far more complex than that. And many people want to be resuscitated infinite number of times or be kept alive for many, many years, while many others don't want to be resuscitated ever and would not want to be kept alive for a very long period of time at all. So those first intro statements basically say that. I encourage everybody, as it is with every single legal document, read it thoroughly, read everything, and feel free to reach out with any questions you might have, as well as bring them to the Q&A that we're going to host next Wednesday, April 8th from 3 to 4 p.m. So moving on, notice at the bottom of the page, you're going to always see the name of the document with a page blank of blank and then a space for your initials. So again, you should only fill in that page blank of blank and the initials on the day you actually sign it. And the page blank of blank is just, this looks like it's going to end up being a 7-page document. So it would be page 1 of 7, 2 of 7. And then you want to initial each page. And these seem like small details, but they're actually quite important for proving in court that these documents are valid. It's more important when we're talking about powers of attorney and wills and healthcare directives, but it's still really critical, and I encourage you all to pay particular attention to that. So the issues for point 2 on the healthcare directives. This is where we're starting to deal with really basic, clear first instructions about if I am dealing with immediate resuscitation and kind of prolonging of life issues around general medical issues, not COVID. What do I want, right? So again, I'm going to be using examples for myself, and I'm actually using examples that are not true to my own personal values. So I'm going to be using a more common example of what I've seen. There's a kind of average that folks will have about how long they want their lives prolonged. My personal experience is actually, I'm an exception, and I prefer personal situations that most people I have seen in practice wouldn't, where I want to be kept alive as long as possible. And so that's okay to say, which is why I'm bringing that up, is that the examples I'm giving you are more common. They're more kind of middle of the road. But if you find yourself to be a person of extremes in your values for this, you should still be honoring those in these documents. So my actual real documents, not these examples, they have very different assignments, and they're quite long compared to other people's. So don't feel bad if you're a person that's like, nope, keep me alive for 30 years. As long as you get your doctor to sign off on that on the post, or as long as you've been clearly informed about that decision and you make it clear in your paperwork, that is okay. So for prolonging life, I put here, as you can see under 2.1a, that I would want to be prolonged for 3 months, within the general accepted healthcare standards. And again, this is for not COVID related stuff. And you'll notice at the bottom of the page, there's a spot under 2.1b for extraordinary measures. And again, this is not COVID-19 related. This is just regular old stuff. And so you'll start to see that a lot of the repeated values coming up in these questions are what ways do I want my life prolonged and for how long? And then the bigger questions that are always considered repeatedly is, which is more important to me? Staying alive, even if I'm in pain, or even if I am a burden to myself or my family? Or is it more important to me to not be a burden financially or otherwise to myself or family, and it's more important for me to not be in pain? Any and all of those desires under that spectrum of choices are all valid and all important, and whatever yours are crucial that you express them how you would want. So here you'll see that I checked, you'll see the DW with the X next to it down there under 2.1b. And anytime on these forms where you see those two little do not or do want checkboxes, that's what it wants of you. You need to put in your initials and an X, just like you would be initialing and Xing a document. And you get to pick. You can say, I do want extraordinary measures to prolong my life, or I do not want extraordinary measures to prolong my life, right? So you can see there that I checked that I do. And as the document goes on, you get to elaborate on those methods. So now we're going to look at burden to family with 2.1c. And on 2.1c, you'll see that that's the statement of, is it more important to you to have your life prolonged, even if you're a burden, or that the burden on your family is actually something that you would not want to be? So a lot of folks in my practice have often picked the bottom option, right? The one that says, I do not want my life to be a burden upon my family. So if two doctors consider me to be medically brain dead, and my attorney in fact determines that in my best interest to do so, please do not continue life support measures. That is not the option that I chose for this example, but many, many people that I support have. I picked the one above it. You can see the DW, my initials again, Dusty Weber with the X, and it's more important for me that my life be prolonged. So 2.1d is vegetative state. If two doctors believe I would remain in a persistent vegetative state, what do you want, right? So again, we are talking about general big medical decisions, not COVID stuff. COVID comes up in section 4. We'll get there. So vegetative state, you have two options again. Would you prefer to have your life prolonged as long as possible, or would you prefer to not have your life prolonged? I, again, chose to have my life prolonged. It is okay to have some variance around how you express these values, but I would heavily encourage you in practical wise to keep these statements as close to the wordage included as possible. Don't try to deviate or edit much on these statements. There are some spots where you are able to add in personal care and values and things like that, but when it comes to the vegetative state instructions, life-sustaining decision instructions, these are crafted to be medically clear to your medical providers according to the language they need to see. So I would really caution you from changing those as much as possible, and try to just follow the fill-in-the-blank method if you're able to. For 21E, for life-sustaining treatment decisions, again, this is about, do you want your powers of attorney, your agents, to think about your quality of life and relieving your suffering alongside prolonging your life? Or do you want the prolonging of your life to be the #1 priority no matter what, right? People kind of typically fall into one zone or the other. And deciding which one is the most important for you will be what you pick. As you saw there, I chose the bottom option with the DWX there next to what says, I do not want my attorney, in fact, to consider relief of suffering or quality of life. It's not because I want to suffer or I want anybody to see me in pain, but it's because my primary wish is to have my life prolonged, even though it might be the detriment to my quality of life, right? So an example of that is, folks wake up from comas after 10 years. Quite often, there's lots of medical evidence for it, or after many years. And there are a few exceptional circumstances where even after decades. And some of these folks have been able to regain parts of their life and livelihood in their abilities in ways that were not predicted when they were in the coma. So it might not seem practical. Our intuitive emotional heart says, no, don't let Dusty suffer, right? Like, don't let his quality of life be so detrimental. But if I have a value of survival that is my most important, this gives me the opportunity to express that. Just the same, if you're a person that absolutely does not want any suffering for yourself or to be a burden on others, it's going to be really important to express that desire instead. Okie doke, so 2.1F, we're looking at place of death now. You can determine and express whether you want to die at home, at a hospital, at a hospice, or at a special place listed below. For example, like if you're in a special care situation. And again, this is a request, right? I think that caregivers and medical providers will try to honor this as best as possible alongside your agents, but this is just a request. And then 2.2, we're going to start talking about relief from pain. So this is old school estate planning. This was called the morphine clause. It's kind of like, and you will still actually see that in other outside estate documents you might use. It's basically saying is that, do you want to be given treatment that will make you be in less pain, even if that treatment might make you more likely to die, i.e. morphine. If you've ever supported someone through the death process, you have probably seen that morphine can be a great aid for people at the end of their life in making their suffering much more limited than it would be otherwise, but it also hastens their death. It can bring a death quicker than otherwise would be happening. So a lot of people have very particular values about that, and you get to evaluate how you feel about that and whether you would want those kind of treatments or not, considering the potential of your death coming. So again, you can see I chose the bottom one that says that I would rather have treatments for pain alleviation be withheld, and I would prefer to prioritize my chance of recovery instead of the relief of pain and suffering. Okie doke. So this is just some definitions. There's nothing for you to fill in, but it's good for you to read over them, and especially anything you're signing that's expressing your wishes or anything you're ever signing, you should always read over. So it defines terminal condition for this paper. It defines the unconscious state definition for this document. And then it's got a new one that I added in that I had never made before for a state document. It's called exceptional and novel circumstances definition. And this is about COVID-19. So I wrote this to apply to all of the circumstances we are all facing right now with COVID-19, but I also wrote it to be inclusive of any future contingencies and illnesses and conditions we might not be able to know of at this point that could be similar. So you'll see that the definition says that. It says that I, meaning you, the person making the document, intend for the terms exceptional and novel circumstances to include but not be limited to COVID-19 and other novel virus influenza or yet unknown conditions. And there is a section coming up, section 4, that readdresses COVID-19 issues and gets specifically into that. So section 3 then moves on to addressing treatment during terminal and permanent unconscious conditions. So this is what you would think of as the more general, normal healthcare directive stuff. So again, we're not in COVID stuff yet. We're talking about what happens if I end up in that car accident on the way home from this recording and I am in a coma, after surgeries and things like that. What would I want, right? What if there's some unknown recovery chance, or if recovery chance is something where the doctors are wanting to consider my documents, this is your opportunity as a person to let your caregivers and your care providers know what your desires would be. So for me, according to this example, if I'm in those kind of situations where I'm in a terminal condition or a permanent unconscious condition, I would like, there's typically 4 types of care, A through D, that we'll go through. There's the artificial nutrition, which I would want for 3 months during this kind of circumstance. There's the artificial hydration, which I would want for 3 months. Then we move on to the artificial respiration and or ventilation, which we're all really familiar with right now, which again, I said I would want for 3 months. Now that might all be different under COVID-19. So in section 4, I actually might want it for longer if I'm being treated for COVID-19. But if I'm being treated for that coma after the car accident, then you're going to want to stick to these regular guidelines of the 3 months. And then finally, avoid any treatments that might hasten your death. And again, to be consistent with the example that I gave earlier, I would choose on my document to avoid morphine or to avoid any kind of medication or treatment that might make me more likely to die, even if that means I would be in more pain because of making that choice. Okay, So most of everything we just talked about, if you've ever done a healthcare directive, you've probably seen before. Now we're going to talk about some brand new stuff. All of the A through D is the exact same that we just covered, but the intro part is brand new. So I really want to bring that up and describe it. So you'll see that you're going to be dealing with your decisions around what I am calling exceptional or novel conditions, such as COVID-19, right? So and in it, you're saying that you're requesting the following treatments regardless of the end of life desires that you express for use under normal circumstances. Meaning anything that you directed for your treatment in section 3 might be different than what you've directed in this section, and that is okay. And you still intend for them to be honored during their particular circumstances. So this directive specifically says it should be consulted as the primary instruction if you as the principal are being treated for a novel, exceptional, or previously unknown condition, right? So, then it goes on to be specific that if you're being treated for conditions such as COVID-19 or anything like that, that you would prefer for this section, section 4, to be the directives for your care. So again, we're going to look at the 3 types of treatment: nutrition, hydration, and respiration or ventilation, and then the pain relief morphine clause. So for COVID-19, because it's changing rapidly, because we're all facing pretty uphill battles, and because the care is at capacity in many institutions, many people have expressed concerns about being able to say that they would want to be kept alive or have their life prolonged longer than they normally would, or they want to make sure that it's clearly listed somewhere, because as everyone's been hearing, there's a lot of risk of hospitals having to make values decisions about who lives or dies when we have a lack of access to the amount of ventilation machines that we need, or ICU beds that we need, and things like that. So you can see here that I have changed from 3 months to a year on all of my decisions. So for the coma after the car wreck, I might be okay just being having my life prolonged for 3 months. But if it's COVID-19, I might want to give it a longer fight. It could be the reverse. If I'm in a coma for a car accident, I might want to be kept alive a year. But under this section for COVID-19, I might recognize that, I would really, under these circumstances, only want to go through it for 3 months. It's a pretty intensive experience. You need to think about it's not just a year of provided nutrition, or a year of provided hydration, or a year of provided ventilation. But with COVID-19, we're also looking at a year of isolation, a year of no visitors and no pets, a year of no guardian coming to see you. And even if your guardian is able to come to see you, it will be very limited, and they will have to be going through pretty intensive medical tests to be able to do that, like most caregivers who are trying to access people in nursing homes right now are having to go through. So thinking about those kind of things could be quite important. And, similar to the next slide, your pain alleviation statement might be different. I did not change mine. You can see that under COVID-19 issues, it still says that I would like my life to be prolonged over the using a pain medication if that would hasten my death. But a lot of folks might want to do the opposite. You might say, no, under this circumstance, I would prefer to have morphine, even if it makes it more likely that I would die, because the inflammation is pretty severe, and there could be quite a lot of pain associated with COVID-19 compared to other kinds of conditions. So the final thing is that this is an extra statement that you won't have seen on the regular general consent. Part E, under section 4, part E of the COVID-19 section, there at the bottom of the screen right now, you can see that it says, I understand that novel conditions like COVID-19 might require experimental treatments, some of which may include blood transfusions. And the reality is that they may include many kinds of treatments that are already on our radar, or that we haven't even really been made aware of yet, or discovered yet. And so this is a broad consent right here. And it's one where you should think about it, and think about the personal, spiritual, physical, and so on implications of it, and whether you would or would not want to consent to those kind of experimental treatments. So as you can see, I put DWX there next to consenting to the experimental treatments. However, it's important for everyone to know that if you choose to not consent to experimental treatments, many of the only treatments available for these kind of novel conditions are experimental. So if you choose to not consent to experimental treatments, it is a risk that at certain times or certain medical situations, if you have said that you refuse experimental treatments, you might not have any treatment options available to you for these specific novel circumstances, right? So a good example is that if you're living with cancer, there are so many kinds of experimental treatments for cancer, out on the market for people to access right now, and that are changing all the time. That's going to fall under your normal general healthcare directive earlier, which really doesn't really address much experimental treatment. It talks a lot about general standards of medical care, because typically with situations like cancer or other diseases that are not COVID related or COVID similar type novel circumstances, you're going to be able and going to have to execute very specific experimental treatment related consents specific to each of those treatments. So there isn't going to be as much of a crisis need for it like there is for this kind of statement. And while I do encourage everyone to make these decisions according to your values, it's important that you do so informed. And so it is make an informed decision that if you reject experimental treatment for COVID-19 type novel circumstances, you may be rejecting the only available treatments that are out there right now. Particularly, any new treatments and novel treatments are going to have to begin as experimental when we're facing these kind of novel diseases. All right, getting towards the end here with the healthcare directives. So you've got a consent to electronic treatment. This is very broad and it's very clear. It just says that you consent to be treated by video, telephonic, and other internet-based or digital kinds of communications. And then a quick plug again for transgender, gender diversity related issues. So for folks that aren't trans, you're not necessarily going to need this, right? This is some very, very specific trans and gender transition related stuff. Not all trans folks are going to need this, right? There's tons of ways to be trans. Many of us do not change our bodies or names, many of us do. And so there might be different ways we need to express that in these documents. There is one shared issue, and that's the exclusions. So again, if you really want to exclude people from being able to visit you, you would want to look at those statements and make sure you have them in your documents. But as far as medical care, there's a whole section just in the trans healthcare directive that deals with that. And the first statement says that you're explicitly requesting that if I become incapacitated, that all transgender care be continued according to how my personal choices were at the time of becoming incapacitated. And it says to request to continue hormone treatment as long as you're able to, and continue all other medical treatment or surgical recovery as I was taking or undergoing at the time of my incapacitation. The one thing you can't do is probably say, go ahead and put me through a surgery I had planned. I know that tons of trans surgeries are on hold right now because of COVID-19. And as a trans person that really benefited from a gender-related surgery in my lifetime, I feel great empathy for my community that this is one of the side effects right now. And so you can say in your healthcare directive, yes, still give me top surgery, even if I'm in a coma. They're not likely going to do that, right? But you can request that your surgery recovery continue and things like that, right? So if you're doing dialysis, dilation, anything like that, you should still be able to have your caregivers continue that if you can't do it for yourself. And then it goes into the stuff that you can actually fill in the blank for 2 and 3, right? So you need to, or you have the right to request to be housed, treated, addressed, dressed, and referred to according to your lived gender. So you can write male, man, masculine, right? Or whatever your lived gender is. That's just the example for me. And this is important, I think, because you'll see at the webinar where you can see us next Wednesday from 3 to 4 on April 8th, that I present what would be considered traditionally masculine. I have a beard, and usually am presenting in a way that most people would read as a quote unquote man or a masculine person. But in the context of medical care, right? Like just thinking about any medical provider handling my body while I'm incapacitated, I have a very mixed gender body. And so it's going to be an issue to make sure that medical providers know that even if they see a body that might be presenting mixed gender signals to them, that I identify and live as a man, as a masculine person, and that is how I want myself treated and expressed. You get to list the name you want to be called, right? And this is the name, it just says, this is the name that I am using. It doesn't say it has to be your legal name. So if you haven't gotten to access a legal name change yet because of the immense amount of barriers to accessing them, first, please get in touch with any of us providers to help you with that. And second, you can still ask for your chosen name to be used as an AKA. It just will not be your official medical record name. To have your official medical record name changed, you're going to have a legal name change and typically update it with Social Security first. And then there at the bottom, you'll see you get to list your gender, however you want to describe it. I describe mine as male or trans man, typically, or I would say transgender is normally how I would identify, but in the medical setting, I was trying to give them some guidance, right, for how to treat me in a gendered setting. And then I listed my pronouns there at the very bottom, he, him, and his, just to be really clear. Again, a good example was that if my mom ended up getting to be the caregiver for me, I've been out for many, many, many years and have a good relationship with her, bless her, but she still will call me she all the time. And calling my old name all the time. And I guarantee that if I was in a coma, she would be messing up and calling me my old name and she to the nurses. So this would allow, folks to be able to be like, Dusty clearly uses he, him, no matter what my mom might be doing or messing up. All right. And then finally, kind of returning back to, slide back a little bit there. There we go. So after the transition-related care, we're going to go back in to the regular final decision. So you get to determine your last rights. Transition-related care in the trans healthcare form is going to be section B. But if you're not using the trans healthcare directive form, the letters are going to be a little bit off at this point because the trans healthcare directive has that extra section. So you'll actually be on, your last rights will be point B instead of C here. But that'll be the only difference, is that they'll just have that slightly ordering difference. So last rights, I'm going to direct it in my final moments of life that there either be a performance of last rites according to the following instructions, or you'll see that or over there be no religious ceremonies or religious last rites of any kind from any religion whatsoever. So again, we're kind of in binary options here, like the documents are. You have kind of two choices generally. So you get to choose whether you want last rites or not. And then if so, you get to say according to what. So you see that I chose to have last rites according to the Gnostic tradition. So you can say, I choose to have last rites according to the Catholic tradition. I choose to have last rites according to the Jewish tradition or Buddhist. You can say performance of last rites according to any tradition except the following tradition. If you want to exclude anything and say, the performance of last rites according to any tradition except Christianity or any tradition except the Gnostic tradition, like was listed on there. Sorry about the screen. So you have a right to list that as well. If you have a person that you want to provide last rites, you could also say that there and suggest them. Point D, you can list your doctors of choice. So I designate my physician of choice as Dr. 1 of one medicine and alternate as Dr. 2 of hospital 2. So you want to say what their name is and then ideally a place or a point of contact for them so that they can be accessed, right? Because my primary care doctor, who's also my trans care doctor, has a ton of information about me to give to any medical provider that might be helping me in a crisis or an emergency. But unless that provider knows how to get a hold of her, she can't give them that info. And then, it says finally on E that if your physicians that you've named can't act as your physician, then you prefer that your designated health agent determine a suitable physician. And coming to the close of the documents now, we're going to talk about sort of where life transitions to death. So organ donation can be determined, one, by the different companies that you have already set up an organ donation plan with, where most folks that are going to donate organs, it's not really as simple as just checking it on your license. There's often quite a lot of different, different groups that are doing it or organizations that are doing it, different hospitals, different universities. And there are lots of different science programs, different body part banks, right? Washington has an eye bank if you just want to donate your eyes to science and things like that. So you can basically instruct for your organ donation on this form, but a little bit of practical advice is that there typically involves quite a lot of setup otherwise that you need to do ahead of time. If you're an HIV positive person, there's some really incredible laws just about HIV positive people being able to donate organs to other HIV positive people. And there's a huge need for pause to pause organ donation right now, particularly around kidneys and other organs that take a really hard hit from the pause related treatments that folks have to be on. So there's some pretty cool specific LGBTQ organ donation stuff that comes up around those issues. And you need to make sure to deal with that ahead of time. But on the forms, you can just say that you do or do not wish to donate your organs and according to what instructions. I don't wish to have my organs donated, so I checked that I do not want my organs donated to any program whatsoever. If you did want that, then you would instead put your initials there below where you do want them donated and provide the instructions on the fill in the blank spot. And then finally, the release of your body. Now this also is going to show up in wills or funeral instructions as well, and it can show up in a power of attorney. Basically, anywhere in any of those forms that says your body can be released to these people, they should be honored. And as many times as you can list it in as many of those forms as possible is better, because at any given moment, people aren't necessarily going to have access to all the forms. So at least having it on one of them will give someone direction. So I just say that upon my death, my body can be released to the following person or persons, and I list my brother Dan and my friend Mary. All right, so then the end is just a bunch of kind of important legal statements. You should all read them, right? There's a bunch of letters all the way through L that will kind of describe more about this legal document that you're finishing. And then it gives the attestation, saying that you had capacity to execute this, that these are your wishes, these are the instructions that you provided, and that you're aware of the future possibilities for what you're signing. So I've left blank the signature spot on the bottom just to remind you that you are going to finish that when you are actually signing and executing the documents themselves. Okay, so the physician's order on life-sustaining treatment, forgive my terrible electronic handwriting, it's not much better than my non-electronic handwriting, but the post, this form, which is front and back, so this is the front form, this one typically is going to be on a green piece of paper and is best completed by hand if you can. If you have a program like a PDF filler that will fill it in, that's fine, but the handwritten really is the best way to get it done, and it doesn't take very long. You'll see that on the first section, you see my name. I did not put in my date of birth or my social security numbers, but you should. I just didn't do that for privacy reasons here. And then the medical condition or patient's goals. This is about the emergency treatment stuff. So my number one goal, even though I have a lot of other medical conditions, when we're talking about emergency treatment, my number one goal is prolonged life, which is why you see in very big bad handwriting, I put prolonged life up there. And then we go through sections A through C. A is really about CPR. It's about life-sustaining or life-saving, procedures. Do you want resuscitation in CPR or do you not want it, right? And this is when you have no pulse and you are not breathing. It's a very specific medical circumstance. You get to choose. Either you want to attempt CPR or you don't. I picked that I did. You see my check mark up there at attempt CPR. Section B, medical intervention, right? For when the person has a pulse and is breathing, but we're dealing with all the other considerations that we just talked about in the healthcare directive. This is just the emergency orders about that stuff, right? So mine would be, there's 3 options, read through all of them and read through the instruction sheet that we have included that comes with this form that really describes the difference between full treatment, selective treatment, and comfort-focused treatment. Mine is full treatment, meaning that prolonging my life is my number one goal. And then again, the additional orders you see I wrote in, keep alive 6 months, just as an extra note that I would like my life prolonged as long as possible. Section C is the signature section for the front page. I am saying that to remind you that there is a back page that also has things that you should complete. The highlighted areas actually need to be signed and completed by your doctor. Your natural practitioner, your PAC. It doesn't have to be just an MD medical doctor, but according to the instructions, whoever is qualified to sign it, usually it'll be a prescription writing level person, will need to complete those green areas, and then you will be completing the patient name and signature and date. The bottom, it says, where you can see that I've checked under my signature scribble there, you can see that I have checked that the person has 1, a healthcare directive, and 2, a durable power of attorney. This is good because then it says to the providers and the person helping use these forms, hey, this is the emergency instructions, and now go look at the longer form instructions, right? And then the back side is a HIPAA release, as long as these names are on here, and then the contact info, right? So up at the very top, it's just my name listed, and then the name of my guardian or contact person. So this at least says that, you know, my brother Dan can be contacted about this information in the case of emergency. And then point D is about non-emergency medical treatment preferences. So it's about, I've already had the car accident. Now I'm just having to stay in the hospital for a week afterwards while my leg is setting, you know, after surgery or whatever. And so during that time, what do I want, right? And so antibiotics, let's say there's also a risk of life because of some infection, or risk to my life because of some infection. Would I want antibiotics or not, right? So I would choose to have them. Would I want medically assisted nutrition or not? Yes, I would. And you have 3 choices there, right? So for antibiotics, you can either do want them or you don't. For medically assisted nutrition, you can either have none at all, or you can have a trial period where you get to determine the length, and you can see, you can write it in there as the goal with the timeline, or you can just choose long-term like I did. And then finally, just above the green signature spot again, and the patient signature spot again, because you need to sign it twice on the front and back, your doctor needs to sign it twice on the front and back, are the additional orders. So the additional orders spot, this is where you might want to just briefly list issues you're living with, anything you might be important. So I put continue hormones, is transgender, has PTSD, right? Things that would be really important for care providers to know if I was in inpatient care in an emergency, or kind of, you know, unexpected situation, right? Not planned care. If something happened where I was suddenly in a medical facility that needed to know about me in a really quick way, that's the things I would need them to know. And then there's a bunch of directions for your healthcare professionals, including updating the form and reviewing it with you there on the bottom. So the post form, there's a lot of really helpful information out there about it. And if it's confusing to you in any way, I encourage you to dive into the resources and look through the instructions. So now we are definitely getting a little over on time, so I appreciate y'all's patience, but we're getting to the end of the forms now. And just keep taking breaks and pausing as you need to, and just keep a note and keep, you know, just a little marks for yourself about any questions you might have about all the forms, so that we can go over them when we're together on the webinar live next week. So the HIPAA release, pretty self-explanatory, right? You're just gonna have your name, your date of birth, your social security number, and then you just restate who you are and who you give your HIPAA release to. So this is a HIPAA release that we've made that gives permission to access medical records and has the very federally explicit required HIPAA Portability and Accountability Act statement. And then again, at the bottom, you need a sign, print, and date. So you see here, I gave HIPAA release to both my brother and my friend as a good example. It doesn't always have to just be, you know, partners, romantic partners, or biological relatives. It can be friends and chosen family as well. So power of attorney, there's not really as much, honestly, values-wise to talk about. So it's kind of funny because a healthcare directive is only usually 6 pages long, but it can take so long to figure out and decide what you want in it. Power of attorneys, on the opposite, are often twice as long. I think the one we included for you all is like 14 pages, but most of it is just fancy lawyer words that are important but don't require much for you to decide. So the things you have to decide really are, who do you appoint? Who do you want to give financial power to? Who do you want to give healthcare power to? Who do you want your backup agents to be? And you'll see that is most of what this first page is, right? Is I've included my name, Dusty. I'm giving the powers to Dan Weber and Mary Russell. And then it just explains that. It says, I, Dusty, you know, hereby appoint Dan Weber of Seattle, Washington as my attorney in fact for finances. And if Dan can't act, then I appoint Mary. And then the bottom part underneath that says the same thing, but for healthcare. It says my attorney in fact for healthcare. And I have Mary as my attorney in fact for healthcare, and Dan as my backup to her. So it's the same agents. They're just, each one has a power for different stuff so that they both don't get overwhelmed if I'm ever in care and need them to manage things. You will notice though, in bold, at the bottom of that first paragraph, there's an exclusion that says, at no times are any of my biological family members to be designated as attorney in fact or agents with any power of attorney over my financial healthcare decisions whatsoever under any circumstances. So my little brother is my biological family, so technically that doesn't apply here, but I left it as an example because most folks that have homophobic and transphobic families are going to want to have a statement like that in there, right? It's not going to be their biological family who's an agent, like my brother is. It's going to be their chosen family, you know, their relations, their romantic partners. And so those are the folks that you want to list. And if you want to exclude your biological family, that's where you need to have that kind of exclusion statement. The other important thing about this page to notice, though you don't need to fill in any of the blanks, mostly all you're filling in here is going to be names. You know, there is a statement at the bottom that says that your agents can act independently of each other, which is important and required under our law. So that's already included. And you'll notice there's one blank spot that says that I didn't complete, and there's a spot next to it that says date, where it says that I want my healthcare agent to manage all of my healthcare decisions based on a document that I supplied, that's a healthcare directive, and it says sign on the blank date. So you don't want to fill that in until you've actually signed your healthcare directive. So usually you'll just know the day that you've planned it, and you'll be like, okay, I know that on April 20th, we're all going to get together and sign all my documents. So I'll fill it in that I signed the healthcare directive on that date. That way, Mary, my healthcare agent, knows, oh, Dusty's most recent healthcare directive is from April 20th of this year. That's the one I'm going to look at to make sure I know his most recent and relevant medical desires. All right. So most of the power of attorney stuff is just fancy language, and you all should read through it thoroughly and definitely reach out to us or bring to the live webinar any questions. Main things I want to just tell you about: this one does revoke all previous powers of attorney. It's effective right away as soon as you sign it, and it's durable. Right there, you'll see the effectiveness and duration, right? There's actually 2 durability statements in this one, just to make it really clear. There's another one right again at the end, just to make it very express and obvious that this is a power of attorney that is going to continue even if you're disabled or incapacitated. So it's effective immediately, and it's durable. And then it starts to list all the different authorities. So as you'll see, the cover page for our power of attorney has a big warning to you that is not required under Washington law, but is what I was taught under California law as statutorily required, and I include it because I think it's good to give everybody a heads up that powers of attorney give people great and broad power in your life, especially under Washington law. We have pretty broad powers of attorneys, power of attorney law here. So a person can access your accounts, sell and gift your property, give things to themselves and other people, manage your beneficiary payments, manage all of your SSDI and insurance issues. There's just a broad way that a person can financially manage and control your life as well as all your healthcare decisions. So this starts to list all the different ways. You should be very clear about them and read through them and make sure you know what you are consenting to. And then there are a few things you do need to fill in. So for 4.6, if you have completed funeral instructions, or what's in our state, the fancy lawyer word is disposition of remains, or DOR, which there's a version of that included in our website materials. You want to put the date that you signed that document so people know to reference that. The same thing with funeral and burial care authorization. Sometimes they will be different forms, sometimes they will be the same one. So even if they're the same form, it's okay, just put in that date again. And then there is always authority that cannot be granted under Washington state law for powers of attorney. So they cannot, make, amend, alter wills, codicils, or community property agreements. So basically, very specific estate agreements cannot be affected or altered by your powers of attorney, but other things can, including property agreements for real property like mortgages, homes, things like that. So be cautious and highly intentional, about who you apply these powers to, who you give these powers to. So for the healthcare decisions on Section 5, again, you just need to make sure to fill in the dates of the time and date, or the date that you signed the healthcare directive. And then moving on to the rest of 5, it just talks about what the obligations that your agent is taking on for healthcare, right? So it talks about complex treatments. It talks about copies of your power of attorney. Read through all of these things, become familiar with what they are. They will help inform you about the powers that you're giving to these people to make decisions in your life. It does include the access to medical records and HIPAA statements that we have already talked about. And the standalone form also has these. So you can execute just the power of attorney or just the standalone form, but the standalone form will only be a HIPAA release, whereas the power of attorney has all the other things in it as well. talks about that your power of attorney can employ people to take care of you. They could admit you to facilities, including nursing and residential facilities. The one limitation under Washington state law is that there is no authorization for people to arrange for commitment in mental health facilities beyond typically 3 days, right? So if anybody is going to commit you, even a person with a power of attorney that you've given them power of attorney for, there will still have to be a judge involved after a mandatory period of a couple days, usually 3 days. So that is one limitation, that even though my powers of attorney could commit me to any other facility, if it's mental health treatment inpatient, there is a limitation on that. As well, there are some statutory, meaning mandatory under our state laws. There's some statutory requirements for consent that can't be passed. So no one can consent to the basically to psychosurgery, to any kind of therapy or procedures that induce convulsions, like electroshock therapy, or sterilization, right? So under Washington power of attorney law, no one can transfer those powers under power of attorney. I have added in some extras here. So you'll see that there is also no consent here for conversion therapy, right? No one can consent for you to have sexual orientation or transgender conversion therapy. And I included a proactive consent for giving transgender related drugs and care. So it says that you do consent for transgender care, like continuing your trans affirming care, and that you deny anyone the ability to ever put you through transgender conversion therapy. And just a little bit of info about what that is for folks who might not know. While transgender affirming care is what I get to make sure that I get to live as the trans person that I am and know myself to be, meaning I get hormones to make myself, appear how I want to be. I've gotten to access a legal name change. I have an ID that has the ID gender that I want on it. Conversion therapy is the opposite. It is the pray the gay away, right? Or the, make a trans person not trans type therapies, right? So they are illegal in our state for people under 18, but they can still be used. People can be shipped out of state for them. So I've added a ban on that here in the consent to procedures section. And again, I added a statement where it expressly empowers the agents to advocate for, consent to, and refuse consent to all transgender and gender-related treatment and care that you may need at the time of your incapacitation. And then there's just a few more kind of power of attorney things. So reserved rights issues that you should read over, basically saying that, even though this is effective once you sign it, as long as you still have capacity, you still get to be the one making your decisions. And that even if you can have an informed capacity only about a part of the time, about a part of the decision, that's okay too, right? So this is read that reserved rights part and make sure that that is appropriate for how you would want to express your needs. And then add in the date that you have signed the healthcare directive to send your power of attorney to that spot for when they want to determine the withdrawal or provision of life-sustaining procedures under 5.7. So visitation rights, again, we don't know if we're going to be able to get them under COVID-19, but here you can list that your attorney, in fact, your agent has the right to visit you the same as if they were related to you by blood or marriage. And as you can see in bold, you have the ability to expressly empower your agent to deny access to you by your biological family or anyone that you would be planning on excluding. Now, if you want to make sure your biological family can access you, you want to read your documents carefully and make sure you did not download the transgender document or the one that has the exclusion. You can take it out, you can just mark it out, delete it on your word processor, so that if you do want your biological family to access you, they are able to. Because otherwise, your document could create a barrier to them being able to do that. And then finally, at the very end of your power of attorney document, there's actually some really important LGBTQ stuff. So you can nominate a conservator or guardian for yourself. Typically, people will just nominate their attorney in fact for finances or their attorney in fact for health or backups. You can also say that even if none of your appointed people can serve, that you request that none of your biological family members ever be appointed ad conservator, right? So you can still say that, hey, even if Dan and Mary can't do it, make sure that my mom never can do it either, right? And then cultural competency, there used to be an RCW requiring this, that is now gone, but you can still ask for it, and hopefully, the state will accommodate that. If you have to be provided by court an appointment of conservator or guardian for someone to be your guardian on your behalf, you could ask the court to also appoint a mediator of issues to make sure that anyone that's made guardian over you is culturally competent with regards to your gender identity or sexual orientation. And QLaw actually worked on a bench guide for judges that had some pretty good info about this, that many of the judges around the state of Washington should be familiar with, or could be made familiar with if needed. And then 6.2 is where you get to nominate, and 6.3, care for vulnerable adults, minor children, or pets, right? So 6.2, you can see that I don't have any vulnerable children or vulnerable adults or minor children that I am the guardian for, so mine is blank. But you would write, I nominate so-and-so to be the guardian for, and then list the name and age of the vulnerable adults or minor children below for whom you're responsible for. I do have a dog whom I love dearly, and I would be incredibly distraught and concerned about her if I was incapacitated, and it would be my first concern upon waking up if that was the type of incapacitation I was experiencing. So 6.3, I would list, I nominate my friend Al, and this is a good point I want you to notice, is that my friend Al isn't mentioned in any of my other documents, right? Al's got a special role here and is just my pet caregiver. I still would not want Al to be a witness for anything, even though Al is only mentioned here once as a pet caregiver. That's still considered a benefit of the document. So, Al could not be a witness, just the same as Mary or Dan could not be a witness. So then I list that I want Al to take care of my pet, who is Wiley, who is age 15, and she is a dog. And then finally, you can have a point on 7 where you just tell your people how you want your name signed. Even for not trans people, we all have really special ways that we sign our names. And so I, for example, have 2 last names, Weber and LeMay. And for the ease of this example, I just put everything as Weber, Dusty Weber. So I would have my signees sign my name as Dusty Weber. And then I put in an exclusion here in section 8 to exclude biological families from any kind of powers. And this is broad. It excludes them from any medical or financial powers over your person or property whatsoever. And it prioritizes friends, chosen family, and community to have those rights should they need to be determined by a court or other institution or agencies. So again, if you want your biological family to have the right to step up, you would want to remove that exclusion. And a little side note under that, you'll see 8.1, you have the ability to list a name who is to be excluded from having any rights to ever be your power of attorney. I don't have a sister. I wouldn't exclude biological family, so I wanted to give an example of somebody I don't actually have in my family. So I made up somebody named Jane Weber and said that she is my sister and that she would be the person that I would exclude if I needed to exclude someone, so that you have the example there and can see that. And then again, the same kind of exclusion under personal care decisions. On point 9, you'll see at the bottom that it says, I direct that at no time are any of my biological family's members to be in charge of my personal care. And we're getting done now. So wrapping up, we're on the final closing pages of the power of attorney. So what you see here is, again, 18 is the restatement of durability. Just again, that this power of attorney is not affected by your incapacitation, meaning it will continue even if you are incapacitated. And it only ends if specifically revoked or terminated by your death. And then the applicable law is going to be Washington that governs it. A copy has the same effect as the original. And if you have attorneys that you have worked on at any point that you would want, have worked with at any point that you would want to help guide one of your guardians or agents in the decision-making process and how you use these documents, then you have a spot here where you can suggest the attorneys of any of the law firms that you've worked with, or that you would just suggest sending folks to if they need legal help, should you want to. And finally, again, you're going to do the signed on this day of this month of this year with your signature there, but only in person with your witnesses on the day you're actually ready to make it all valid. The last thing I wanted to draw your attention to before we start to wrap up and just kind of close out now is that on the power of attorney form that we included, Again, you're going to see at the very end, there's Exhibit A that's referenced in the document. It's very important that all of your attorneys, or all your power of attorneys and their page numbers, their page counts that you're going to handwrite in at the bottom actually include the total that includes this exhibit printout. The reason being is that this exhibit printout is the printout that includes a lot of the power lists that are going to be important, including the power for your agents to be able to access all your digital accounts, right? And you want to make sure that you fill in the date that it was executed on. And so a lot of times an account will say, okay, well, I want to see where the power of attorney says that Mary has the right to go into Dusty's social media Instagram account and get on there and get in there and make a post on there. And it's actually this exhibit form that says quite a lot of the things that different accounts and institutions are going to need to see for you to be able to actually act as a power of attorney, or for your power of attorney to be able to act on your behalf. So do not disregard the importance of this exhibit, which depending on how your print runs will be 1 or 2 pages. And so include the exhibit, make sure your name is on top, make sure the date it's executed is on top, and it is essentially just included at the end of your power of attorney right before your witness statement. So your witness statement will always be the last page. So this is just as important as the rest of the document. All right, so speaking of witness statements, I'm going to run you through an example of the witness statement real quick, and then that is the last bit of learning we are going to be doing together today. So this one we're doing is the witness example for the power of attorney form, but this example form is essentially, you can duplicate it for all of your other forms. So it is the same across all of them, for healthcare directive, for power of attorney, for wills, for funeral instructions, but they all, though the language is the same, they're going to have different headings. So you see that this is the affidavit of attesting witnesses to the power of attorney of Dusty Weber. So you want to make sure you don't print the one for the wills and attach that one to your power of attorney. So make sure you have the right witness form for each actual document that's being witnessed. And then most of the fill in the blank is pretty uniform. So you're going to have the date, and you're going to multiple times be writing in your name, usually at least 5 times on each document. It's redundant, but it is about proving over and over again that you were the person doing this, that it wasn't just some one-off kind of thing, but that you were intending for this. You are who you are, that everybody knows you are who you are. So you're the principal. That's me, Dusty Weber. Request so-and-so on part 1. 2 is the execution. Again, put my name, Dusty Weber, your name, you're the one filling it out. And then on this day, on this month, in this county, the same old kind of fill in the blank stuff that we've been talking about. Your name again under the declarations, again under signatures, twice under signatures. And then at the very bottom, you're going to put the power of attorney in the footnote, in the footer, power attorney of Dusty Weber with his initials down there, and then page number what, right? Your witness pages are typically going to be your last one. So it'd be like, page number 15 of 15. This is the witness statement. It's typically 2 pages because they're really long. So you'll see it's got all the stuff you fill in 1 through 5. And then after 5 is what the witnesses are attesting to. So they're saying they're not related to you by blood, marriage, or partnership. They're not your attending physician or working in a healthcare facility where you are. They're not entitled to have a claim to any part of your estate. They're not a person designated to make medical or other decisions for you. They're not the persons, meaning the witnesses themselves are adults who are, have capacity to make this witnessing statement, and that they knew that you did this willfully and voluntarily, meaning I didn't have somebody saying, hey, you have to do this, or I'm going to steal your dog, right? You must sign this healthcare directive saying that, you assign your healthcare decisions to me, or I'm going to take Wiley away. That would be duress. That wouldn't, the witnesses should not sign according to that. So it's important that your witnesses see that you're making this decision normally, for yourself. The most common actual abuse scenario would be an LGBTQ elder being pressured by someone, or a person with vulnerability issues and capacity issues being pressured by someone to have their circumstances manipulated or abused to the benefit of that other person, right? So that's part of why it's so important that our witnesses do take their responsibility seriously and do make sure that whoever we're witnessing for really is doing this willfully, voluntarily, and not under duress. And then very finally, so there's the witness stuff. You'll see witness 1 and 2 need to sign their name, print their name, put their address, which is very important, that they put their address, city, state, and zip. And if you're going to have it notarized, the notary will complete the certificate of notary part. You won't do that. If you're not going to have it notarized, you can just delete that section from your forms. If you are able to, though, remember, especially with powers of attorney, if you're going to use them over state lines, they're most effective and might only be effective if they are notarized. All right. Well, big deep breath. Thanks for sticking through an almost 2-hour-long presentation. There's quite a lot of info. We really tried to cram it in there to cover as much as we could in a short amount of time. Hopefully you took a lot of breaks and pauses. We expect the Q&A next Wednesday on April 8th from 3 to 4 is going to also have quite a lot of questions. In my experience, these issues turn out a whole lot of issues that come up. So definitely get ready, send us anything you might want to ahead of time, and join us for that as you're able to, both for just follow-up help and then for any kind of legal help and professional estate planning. We're going to talk more about who we are at the live webinar, and our contact info for each of our organizations is listed on the screen right now. So we've got Lavender Rights Project with our phone number and email, Smol Law, where you can get Melissa over there at Smol Law, and then how to reach Denise over at QLaw as well, and the QLaw Legal Clinic with either their phone number or the website. And then finally, some non-lawyer professional estate help, although the Northwest Justice Project are attorneys. You can go to endoflifewashington.org. Northwest Justice Project Senior Legal Helpline is very helpful. It often involves access to free legal help and services for seniors over 60 in our state. Washington Law Help has a great healthcare directive resource site online. And then for seniors who are LGBTQ and are looking for different kinds of LGBTQ senior service providers, whether it's professional fiduciaries to be your power of attorney, whether it's professional estate managers, different things like that. I really encourage folks to check out that link for Northwest LGBTQ seniorcare.org. And finally, for LGBTQ friendly funeral home planning and that end of life planning, up on the north side of Seattle, Acacia Memorial Park and Funeral Home is a community member run, very LGBTQ friendly funeral home that comes highly recommended by lots of different community as well. So thank you very much for spending time with us today. And I hope to talk with many of you at the Q&A going to be next week, Wednesday, April 8th from 3 to 4 p.m. The link will be available on the website along with all the other promotional materials to join in with myself, Melissa, and Denise. And we look forward to connecting with many of you then and answering all of your questions. For any of you listening to this webinar after April 8th, because it's going to stay live as a resource on the website, just use any of those different contact ways to reach out to us to get in touch in the future about following up with any of this information, with help on any of the documents, or if you actually just need to retain anybody for legal advice or actual professional estate planning help. Thank you so much, and many blessings for the health and safety of everybody during these trying times. Thanks for joining us today.